great lunch. Court should be starting any minute. Please remember to like, share, and subscribe, please.
You are unmuted.
Jimmy, what are they doing?
What is now open, you may be seated.
So who wanted to see me? I'll see you at sidebar for just a minute. No, Chris, yes. Yes, I'm sorry. Some space here, please.
Hold 1 second.
Okay, Paul.
Rise to the jury.
Jim, now you're gonna have to go through all of those to pick the alternate out?
You okay with that?
Oh, okay. Okay. All right, jurors, I'm going to give you the instructions now in the law. But first, I want to thank you for serving on this jury and for being so attentive. You'll soon deliberate for the purpose of reaching a verdict, but before you do that, it's my responsibility to give you the instructions concerning the law. These instructions are divided into 3 parts. The first part, general instructions that are provided in every criminal case. The second part, specific instructions concerning the crimes alleged in this case. And third, guidelines for your deliberations. Please listen carefully to all of the instructions. Do not ignore any instruction or give any special attention to any other instruction. To make sure that I give you the instructions accurately, I will read them to you. You'll also get a written copy so that you may refer to it in the jury room during deliberations. I will try to make sure that my oral instructions match the written instructions. If there is any difference between what I say aloud and what the written instructions say, please follow what I say aloud. You must take the law as I give it to you. You may not quarrel with it. You can't do that regardless of any opinion you may have as to what you think the law ought to be. Lawyers or witnesses may suggest something about the law. That's not necessarily the law. That's because it's my responsibility as the judge and mine alone to instruct you what the law is. I'll now turn to part 1 of these instructions, which are general instructions that apply to all criminal cases. As I've explained to you at the beginning of the trial, There is a fundamental rule that applies to all criminal cases, including this case. Every person who is accused of a crime is presumed to be innocent of that crime. Ms. Reed is presumed innocent of the charges in this case. That means you must consider Ms. Reed to be innocent unless the prosecution has proved beyond a reasonable doubt through evidence presented at this trial that Ms. Reed committed the crimes charged. I'll explain what I mean by reasonable doubt in a moment. Ms. Reed does not have to do anything to convince you that she is innocent. She does not have to explain anything. She does not have to testify, call, or question witnesses, or provide any evidence at all, because you must presume she is innocent. Instead, it is up to the Commonwealth to prove the charges against Ms. Reed beyond a reasonable doubt. This burden of proof never shifts to the defendant. After you have considered all the evidence carefully and fairly, if you have a reasonable doubt about Ms. Reed's guilt in a particular charge, then your verdict must be not guilty on that charge. You may find Ms. Reed guilty of a charge only if all 12 deliberating jurors agree that the Commonwealth has proved the charge beyond a reasonable doubt. Now, what is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I have told you that every person is presumed to be innocent unless and until he or she is proved guilty, and that the burden of proof is on the Commonwealth. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. How do you decide whether the Commonwealth has proven that each element of an indictment is true beyond a reasonable doubt? Let's talk about the roles we all have. First, the function of the jury. You are the most important people in this room. It all begins and ends with your function. You will determine the facts in this case, and that is your job and yours alone. You are the sole and exclusive judges of the facts. If there are any conflicts in the testimony, it is your job to resolve those conflicts if you can do so. Once you determine the facts, it is your duty to apply those facts to the law as I explain it to you, and to determine whether the Commonwealth has proven its case beyond a reasonable doubt. You must decide the facts solely and entirely on the evidence as you have seen, heard in this courtroom, and on nothing else. No prejudice, no bias, no fear, no favor. You must not be swayed by personal likes or dislikes. Your deliberations are no place for emotion, sympathy, passion, or prejudice. The Commonwealth and Karen Reed have a right to have the case judged by fair and impartial jurors. All parties who come before the court stand as equals before you. Therefore, your verdicts must be based on the law as I'm giving it to you, and on the evidence and the facts that you find, and nothing else. You cannot allow yourselves to be influenced by any personal feelings you may have about the nature of the crimes with which Ms. Reed is known. Justice may be done. Your focus is on the evidence. I am the judge of the law. My job is to teach you the law that you must follow in the case. However, I have no opinion about how you should decide this case. You should not consider anything I have said or done during this trial as reflecting any opinion by me about how you should decide this case. If you believe I have an opinion about the facts of this case, you must disregard it. You must decide this case based solely on your evaluation of the evidence. The arguments of the lawyers are not evidence, they are not witnesses. If a lawyer during argument made a mistake in summarizing the evidence or argued something not supported by the evidence, you must disregard it. It is the jury's collective memory of the evidence that controls the matter. Lawyers' objections are a proper part of the court procedure and are not part of the evidence. So don't hold it against the lawyers or their client if they made objections, motions, or other requests. They're simply doing their job during the trial. There was testimony at trial that the lawyers interviewed witnesses when preparing for the trial. You may not draw any unfavorable inferences solely from that fact. There is nothing improper about conducting such interviews. On the contrary, the lawyers are obliged to prepare their case as thoroughly as possible and may interview witnesses. The verdict must be based only on the evidence and the jury's collective reasoning applied to the evidence in a fair and impartial manner. The extent to which you believe or disbelieve a witness or what an exhibit purports to show, and the importance to give any testimony or other evidence is entirely up to your own good judgment. The evidence consists of the testimony of the witnesses and the exhibits that were introduced in this trial. You will have those exhibits with you in the deliberation room. In addition, as you heard during the trial, the prosecution and defendant agreed that certain things are true. Therefore, you must accept those things as true. There are some things you have heard about that have not been introduced into evidence, such as previous testimony of witnesses, police reports, autopsy and accident reconstruction reports, and perhaps other reports. You may naturally wonder why neither side has introduced any of them into evidence. The answer is that under our rules of evidence, such reports usually may not be admitted, although the parties may refer to them for certain limited purposes while questioning witnesses. So you should not hold it against any party that you do not have them, and neither should you speculate on what they may or may not contain. Similarly, as you review the exhibits, you may find that some information has been removed because it is not relevant. Please ignore that and don't try to guess what may have been removed from there. Any information that you may have read, heard, or seen about the case outside of the courtroom is not evidence. My instructions to you and any other comments I made, the lawyer's opening and closing statements and any comments they made, are not evidence. If the lawyers or I made any comments during the trial, those comments are not evidence and you must base your verdict only upon the evidence. In an interaction between a lawyer and a witness, you may consider only the witness's testimony as evidence. Answers that I struck from the record and told you to disregard are not evidence. Only the testimony of the witness, that is, their answers to the questions and the exhibits are evidence. Finally, on this topic, if one of the lawyers or I refer to some part of the evidence and that does not coincide with your own recollection, it is your collective recollection which you are to follow in your deliberations. It is important to remind you folks that the verdict cannot be based on emotional reaction or sympathy for any person or side of this case. Certain of the testimony and exhibits may have provoked an emotional reaction in all of us. You may feel sympathy for the family of Mr. O'Keefe, and you may feel sympathy for the defendant as she sits here in the courtroom. But your job is to decide the case without bias, fear, sympathy, or favor, to view the evidence with a certain clinical detachment, and to decide the case based solely on the evidence and the application of the law. I have allowed you folks to take notes during the trial if you chose, and you may refer to those notes during your deliberations. But remember, they are not evidence or a substitute for the evidence and your recollection. They are for your personal use. Please do not share them with the other jurors. Please consider the evidence as a whole. Do not make up your mind about what the verdict should be until after you've gone to the jury room to decide the case and you and your fellow jurors have discussed the evidence. Keep an open mind until then. For each indictment, you must decide whether the Commonwealth has proved beyond a reasonable doubt that the defendant is guilty of that specific charge. Your decision as to each charge must be unanimous, meaning that all 12 deliberating jurors must agree. You will receive one verdict slip for each indictment, When all 12 jurors agree on the verdict for a particular indictment, the foreperson should check off that verdict and then sign and date the slip in ink. For each charge, if you all agree that the Commonwealth has proved every element of the charge beyond a reasonable doubt, then you should find Ms. Reed guilty of that charge. On the other hand, if you all agree that the Commonwealth did not prove one or more elements of a particular charge beyond a reasonable doubt, then your verdict must be not guilty on that charge. You'll remember that we took a view in this case. It seems like a very long time ago, but we took a view in this case. The purpose of the view was to help you better understand the evidence that you heard during the trial and to help you appreciate the locations and their surroundings. Your responsibility in the view was to see the places, observe them carefully, and remember what you saw. The view is part of this case. You may use and consider the observations that you made while on the view in your deliberations in reaching a verdict. The same is true about the demonstration we saw from the witness stand. The demonstration was done simply to help you understand the evidence, and you may consider it in your deliberations. It is the jury's job to earnestly seek the truth of the matter. In doing that, the jury must decide questions of credibility and reliability. The jury must decide how truthful or reliable or convincing any part of the evidence is. You should evaluate the testimony of a police officer in the same way you would evaluate anyone else's testimony. You must not automatically believe or disbelieve a witness just because the person is a police officer. In deciding questions of credibility and reliability, you may rely on your common sense and reasoning powers and your life experiences. Consider a witness's testimony in the context of all the other evidence, not in isolation. You may consider the demeanor, candor, and appearance of the witness in testifying. Who was the witness? What relationship did they have to the case, to the other witnesses or parties? Did the witness have any bias, reason, or motive to give false or shaded testimony? If so, you may consider that bias or motive in your deliberations and ultimately as to whether or not it impacts the credibility of the witnesses and the assessment of the evidence presented. Is the witness someone likely to give an honest and impartial account? Consider not just whether the witness was honest, but also whether the witness's testimony was accurate and reliable, or honestly mistaken. A prior statement by a witness, if inconsistent with his or her trial testimony in any way, may be considered on the witness's credibility and reliability, and only for this purpose. Also, if there has been a suggestion that a witness recently contrived their testimony, you may take into account any earlier statement the witness made which was consistent with their present testimony. The prior statement is relevant only as to the witness's credibility and reliability, and only for this purpose. You have heard some evidence suggesting that the Commonwealth did not conduct certain scientific tests or otherwise follow standard procedure during the police investigation. This is a factor you may consider in evaluating the evidence presented in this case. With respect to this factor, you should consider 3 questions. First, whether the omitted test or other actions were standard procedure or steps that would otherwise normally be taken under the circumstances. Second, whether the omitted tests or actions could reasonably have been expected to lead to significant evidence of the defendant's guilt or innocence. And third, whether the evidence provides a reasonable and adequate explanation for the omission of the test or other actions. If you find that any omissions in the investigation were significant and not adequately explained, you may consider whether the omissions tend to affect the quality, reliability, or credibility of the evidence presented by the Commonwealth. All of these considerations involved factual determinations that are entirely up to you. And you are free to give this matter whatever weight, if any, you deem appropriate based on all the circumstances. During the trial, I gave you some instructions on how you are to consider some of the evidence you heard, and importantly, how you are not to consider the evidence. I'm going to summarize those limiting instructions here. Ms. Reed is not charged with committing any crime other than the charges contained in the indictments. You've heard evidence about interactions that Ms. Reed may have had with Mr. O'Keefe in Aruba and others in Aruba. The evidence was admitted solely for your consideration as evidence of the nature of the defendant's relationship with Mr. O'Keefe and whether it goes to her knowledge or intent or motive on January 29, 2022. You may not consider the evidence as proof that she has a criminal personality or bad character. You may not take the defendant's prior acts as a substitute for proof that the defendant committed the crimes charged here, or to conclude that if she committed the acts in Aruba, she must have committed the offenses with which she is charged here. You can only use the evidence for the limited purpose of how it goes to the defendant's state of mind, motive, and the nature of her relationship with John O'Keefe. Before you consider any electronic communication in your deliberations, you must first find that it is more likely true than not that the persons who authored the electronic communications were in fact to have authored or created them. If you do not find it is more likely true than not that the persons alleged to have authored or transmitted or created the communications were the persons alleged to have done so, then you may not consider the electronic communication in deciding the case. Photographs have been entered into evidence, and in some instances, those photographs will be inside an envelope when they go back to you to the deliberation room. The photographs may be graphic and unpleasant. As I told you when you first saw them, your verdict must not in any way be influenced by the fact that these photographs may be graphic or unpleasant. The defendant is entitled to a verdict based solely on the evidence and not one based on pity or sympathy. Consider a photograph only as it may show a medical condition, the nature of the injuries, or the details of the incident itself. You heard evidence of statements made by John O'Keefe. These statements were admitted only for a limited purpose of establishing John O'Keefe's state of mind. You are not to consider this testimony as proof that the defendant has bad character or propensity to commit crimes. The testimony of witnesses recounting conversations with Mr. O'Keefe or messages the defendant's phone received from him can only be used as they go to the defendant's motive or intent on January 29th, and only if you find that Ms. Reed was aware of Mr. O'Keefe's state of mind at the time of the crime and would be likely to respond to it. There need not be direct evidence that the defendant learned of Mr. O'Keefe's state of mind, so long as you can reasonably infer from the evidence that she did learn of it. Now, you have heard testimony about statements allegedly made by Ms. Reed. Before you may consider any such statement, you're going to have to make a preliminary determination whether it can be considered as evidence or not, and for what purpose it may be used. You may not consider any such statement in your deliberations for the truth of any such statement unless, from all of the evidence in the case, the Commonwealth has proven beyond a reasonable doubt that the defendant made the statement that she's alleged to have made, and that she made it voluntarily, freely, and rationally. In determining whether or not any statement made by the defendant was voluntary, you may consider all of the surrounding circumstances. You may consider any evidence you have heard about the defendant's physical and mental condition, her intelligence, age, education, and experience. Your decision does not turn on any one factor. You must consider the totality of the circumstances. Some testimony came from witnesses who saw or heard something. Some witnesses also told you about opinions or conclusions they reached based on some special training or experience. But special training or experience does not necessarily make the witness's testimony any more believable or important than any other evidence. So you should consider the same questions about witnesses' testimony that I mentioned earlier, including any bias or motive these opinioned witnesses may have had to testify in a certain way. You may also consider the witness's level of experience and training, and whether they base their opinions on the facts that you find to be true. There are hypothetical questions asked of some of the witnesses. You may give whatever weight you deem appropriate to the opinion based on the hypothetical, but only if, after careful consideration, you find that all the facts in the hypothetical were true. Remember that witnesses, even those with special training or experience, do not decide cases. Juries do. It is up to you whether to accept or reject, in whole or in part, any opinion or conclusion that a witness offered during the trial. You have the same powers with respect to the exhibits that you do with respect to the witnesses. Look them over and decide the weight, that is the value, that they deserve to receive in helping you resolve the case as you make your ultimate judgment about whether the Commonwealth has proved its case beyond a reasonable doubt. You do not have to believe something simply because it's written on a piece of paper or appears in a photograph. You are not, of course, required to disbelieve it because it appears there. You decide whether to believe what an exhibit purports to show and how much weight, if any, to give the exhibit. Certain charts and summaries not admitted into evidence have been shown to you as testimonial aids intended to summarize, clarify, simplify evidence, or to help explain the contents of records, documents, computer data, or other evidence introduced in the case. Charts and summaries are not new evidence, and you should give them only such weight as you think the underlying evidence deserves. So you've heard me talk about sources of evidence in this case. Those are the tools that you have to decide the case. Now, with that evidence in mind, what can you do with it? As jurors, you may bring to bear all your knowledge and experience. You don't check your common sense at the door to the jury room. Just the reverse. I instruct you to use your common sense. Give the evidence a reasonable and fair construction in the light of your common knowledge and experience. In determining the facts in this case, you may draw reasonable inferences from the evidence that you believe because you're entitled to rely upon both direct and indirect or circumstantial evidence. Direct evidence is evidence of what a witness claims to have seen or heard or touched or somehow perceived with their own senses. Indirect or circumstantial evidence exists where a witness does not testify directly to the fact that is sought to be proven, but you are provided with evidence of other facts and then asked to draw reasonable inferences from them about the fact that sought to be proved. Such inferences may be considered with all of the other evidence in reaching your verdict. Indirect or circumstantial evidence alone is sufficient to establish guilt beyond a reasonable doubt. Now, what do I mean by an inference? An inference is a logical deduction or conclusion that you may, but are not required to draw from evidence that you have accepted as believable. Inferences are little steps in reasoning, steps in which you take some known information, apply your experience in life to it, and then draw a conclusion. Sometimes you can draw more than one inference. You have to decide which inferences are reasonable and decide which seem more reasonable to you. Remember, when you're dealing with inferences, you never have to infer anything. You may, but do not have to draw inferences whatsoever. An inference drawn from indirect or circumstantial evidence need not be necessary or inescapable, but any inference which you do draw must be reasonable and possible. It must be logical. It must be a natural one, which is not too remote in the ordinary course of events. You may not guess. You may not speculate. You may not engage in surmise. You should not pile inference upon inference until the pile gets so high that it tips over logically, or that the chain gets so weak that it doesn't hold together anymore. When you run through your inferences, check the starting point and the ending point to make sure that they're still reasonable. Further, when the evidence tends to equally give rise to either of two inconsistent propositions, the Commonwealth has established neither proposition. In order to convict the defendant, you must find that all of the evidence and the reasonable inferences that you have drawn, taken together, prove that she is guilty beyond a reasonable doubt. Let me give you an example of an inference. Suppose that the issue you must decide is whether the U.S. Postal Service delivered the mail today. If you go home and someone in your household hands you the mail and states that they observed the letter carrier deliver the mail and retrieved it from the mailbox, this would be direct evidence that the U.S. Postal Service delivered the mail. The witness perceived the events with his or her own senses and told you what he or she observed. The issue you would have to decide is whether that witness was credible. On the other hand, if you go home from court and find mail in the mailbox, you may infer that it was delivered by the U.S. Postal Service today. You draw this reasonable inference based on the following known facts. The mailbox was emptied yesterday. You know that the mail is delivered by the U.S. Postal Service Monday through Saturday. The letters in the box are postmarked. You have exactly the same power in this case. Not the power to speculate or to guess, but the power to draw reasonable inferences warranted by the evidence in the fashion I've just described. You may have noticed that Ms. Reed did not testify at this trial. Defendant has an absolute right not to testify, since the entire burden of proof in this case is on the Commonwealth to prove that the defendant is guilty. It is not up to the defendant to prove that she is innocent. The fact that Ms. Reed did not testify has nothing to do with the question of whether she is guilty or not guilty. You are not to draw any adverse inference against the defendant because she did not testify. You're not to consider it in any way or even discuss it in your deliberations. You must determine whether the Commonwealth has proved its case against the defendant based solely on the testimony of the witnesses and the exhibits. Now that completes the first part of my instructions. Now I'm going to turn to the elements of the charges against Ms. Reed. The Commonwealth has alleged that on January 29, 2022, Ms. Reed did assault and beat John O'Keefe with the intent to murder him, and by such assault and battery did kill and murder John O'Keefe. So in that indictment, Ms. Reed is charged with second-degree murder. Now I just want to tell you that our Supreme Judicial Court has promulgated jury instructions on homicide charges that I have to read verbatim. So I want to make sure to do that right. So murder in the second degree. In order to prove murder in the second degree, the Commonwealth must prove the following elements. 1, the defendant caused the death of John O'Keefe. 2, the defendant intended to kill John O'Keefe or intended to cause grievous bodily harm to John O'Keefe, or intended to do an act which, in the circumstances known to Ms. Reed, a reasonable person would have known created a plain and strong likelihood that death would result. I will now discuss each of these requirements in more detail. The first element is that the defendant caused the death of John O'Keefe. A death would not have occurred. The second element is that the defendant intended to kill John O'Keefe, or intended to cause grievous bodily harm to John O'Keefe, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. As you can see, the second element has 3 sub-elements, which I shall call prongs, and the Commonwealth satisfies its burden of proof if it proves any one of these 3 prongs beyond a reasonable doubt. The first prong is that the defendant intended to kill John O'Keefe. This means that the defendant consciously and purposefully intended to cause John O'Keefe's death. The second prong is that the defendant intended to cause grievous bodily harm to John O'Keefe. Grievous bodily harm means severe injury to the body. The third prong is that the defendant intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. Let me help you understand how to analyze this third prong. You must first determine whether the defendant intended to perform the act that caused the victim's death. If you find that she intended to perform the act, you must then determine what the defendant herself actually knew about the relevant circumstances at the time she acted. Then you must determine whether, under the circumstances known to the defendant, a reasonable person would have known that the act intended by the defendant created a plain and strong likelihood that death would result. If you have a reasonable doubt as to whether John O'Keefe's death was accidental because the death was caused by a negligent, careless, or mistaken act of the defendant, or resulted from a cause separate from the defendant's conduct, you may not find that the Commonwealth has proved that the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. In deciding whether the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result, you may consider any credible evidence that the defendant was affected by her consumption of alcohol. If the Commonwealth has proven both elements beyond a reasonable doubt, you should return a verdict of guilty. If the Commonwealth has failed to prove one or more of these elements beyond a reasonable doubt, you must return a verdict of not guilty. Now, the second indictment is the indictment charging manslaughter while operating a motor vehicle under the influence of liquor. And there are lesser included offenses on this verdict slip as well, and I'll explain those to you as well. In order to prove manslaughter while operating a motor vehicle, the Commonwealth must prove the following 5 elements. First, that the defendant operated a motor vehicle. Second, that she operated the motor vehicle upon a public way or in a place which the public has the right of access. Third, that while the defendant was operating the motor vehicle, she was under the influence of intoxicating liquor and or the percent of alcohol in the defendant's blood was 0.08 or greater. Fourth, the defendant operated the vehicle wantonly or recklessly so as to create a high degree of likelihood that substantial harm will result to another. Fifth, that by such operation of the motor vehicle, the defendant caused the death of John O'Keefe. To prove the first element, the Commonwealth must prove beyond a reasonable doubt that the defendant was operating a motor vehicle. A person operates a motor vehicle while doing all of the things, the well-known things that drivers do as they travel on a street or highway, and also when doing any act which directly tends to set the vehicle in motion. A person is operating a motor vehicle whenever they are in the vehicle and intentionally manipulate some mechanical or electrical part of the vehicle, like the gear shift or the ignition, which alone or in sequence will set the vehicle in motion. To prove the second element, the Commonwealth must prove beyond a reasonable doubt that the defendant operated a motor vehicle in a public way. Any street or highway that is open to the public and is controlled and maintained by some level of government is a public way. This would include, for example, interstate and state highways, as well as municipal streets and roads. In determining whether any particular street or road is a public way, you may consider evidence, if any, about whether it has some of the usual indications of a public way. For example, whether it is paved, whether it has street lights, street signs, curbing, and fire hydrants, whether there are buildings along the street, whether it has any crossroads intersecting it, and whether it is publicly maintained. To prove the third element, the Commonwealth must prove beyond a reasonable doubt that while operating a motor vehicle, the defendant was under the influence of intoxicating liquor, that is alcohol, and or the percent of alcohol in the defendant's blood was 0.08 or greater. I will now instruct you on both theories. What does it mean to be under the influence of alcohol? It is not illegal to drive after consuming alcohol as long as the operator is not under the influence of alcohol. However, neither does someone have to be drunk to be under the influence of alcohol. A person is under the influence of alcohol if they have consumed enough alcohol to reduce their ability to operate a motor vehicle safely by decreasing their judgment, alertness, and ability to respond promptly and effectively to unexpected emergencies. The amount of alcohol necessary to do this may vary from person to person. The Commonwealth is not required to prove that the defendant actually drove in an unsafe or erratic manner, but it is required to prove that the defendant's ability to drive safely was diminished by alcohol. You may rely on your experience and common sense about the effects of alcohol. You should consider any believable evidence about the defendant's alleged consumption of alcohol, as well as the defendant's appearance, condition, and behavior. In deciding this theory of whether the defendant operated a motor vehicle under the influence of alcohol, you may also consider whether a blood test showed that the defendant had consumed alcohol. However, no matter what the reading is, the blood test is not sufficient by itself to prove that the defendant was under the influence of alcohol. Under the second theory, the Commonwealth must prove beyond a reasonable doubt that at the time of operation, the percent of alcohol in the defendant's blood was 0.08 or greater. The Commonwealth may prove a person's blood alcohol level by a chemical test or analysis of their breath or blood. In deciding whether the Commonwealth has proved the defendant's blood alcohol level beyond a reasonable doubt, you may consider evidence, if any, about whether the test was administered within a reasonable time of operation of the motor vehicle, whether the person who administered the test was properly certified, whether and how the pre-test procedures were followed and employed, whether the testing device was working properly at the time the test was administered, and whether the test was administered properly. You may also consider any other evidence pertaining to the test or the test results. The fourth element the Commonwealth must prove beyond a reasonable doubt is that the defendant operated the vehicle wantonly or recklessly. A person drives recklessly when they ignore the fact that their manner of driving is very likely to result in death or serious injury to someone, or they are indifferent to whether someone is killed or seriously injured. It is not enough for the Commonwealth to prove that the defendant acted negligently, that is, acted in a way that a reasonably careful person would not. It must be shown that the defendant's actions went beyond mere negligence and amounted to recklessness. The defendant was reckless if she knew or should have known that such actions would pose a grave danger of death or serious injury to others, but chose, nevertheless, to run the risk and go ahead. Whenever I refer to the defendant's state of mind or her intent, you may consider any credible evidence that the defendant was affected by her consumption of alcohol. A defendant may have the requisite state of mind or intent even if she consumed alcohol, but you may consider such evidence in determining whether the Commonwealth has proved this element. Here, the defendant must have intended her acts in the sense that they were not accidental. But it is not necessary that the defendant intended or foresaw the consequences of those acts, as long as a reasonable person would know that they were so dangerous that death or serious injury would probably result. As such, the Commonwealth does not need to prove that the defendant intended to kill John O'Keefe. Rather, this is in that category of cases where public safety requires each driver, once they know what the situation is, to determine and to adhere to an objective standard of behavior. In determining whether the defendant drove recklessly, you should take into account all the facts of the situation: the defendant's rate of speed and manner of operation, the defendant's physical condition, and how well the defendant could see and control her vehicle, the condition of the defendant's vehicle, what kind of road it was and who else was on the road, what the time of day, the weather, and the condition of the road were, what any other vehicles or pedestrians were doing, and any other factors, including the defendant's consumption of alcohol, that you think are relevant. The fifth element that the Commonwealth must prove beyond a reasonable doubt is that the defendant, by her actions, caused the death of John O'Keefe. The defendant caused the death if her actions directly and substantially set in motion the entire chain of events that produced the death. A defendant's act is the cause of death where the act is a natural and continuous sequence, results in death, and without which death would not have occurred. If the Commonwealth has proven all five elements beyond a reasonable doubt, you should return a verdict of guilty. If the Commonwealth has failed to prove one or more of these elements beyond a reasonable doubt, if manslaughter while operating a motor vehicle under the influence of liquor includes the lesser offense of involuntary manslaughter. As a matter of law, the indictment that is before you, which charges the defendant with manslaughter while operating a motor vehicle under the influence of liquor, also charges her with that lesser included offense. The Commonwealth may prove the lesser included offense of involuntary manslaughter, even if it fails to prove the greater charge of manslaughter while operating a motor vehicle under the influence. So I'm going to define involuntary manslaughter for you. To prove that the defendant is guilty of involuntary manslaughter because of wanton or reckless conduct, the Commonwealth must prove the following elements beyond a reasonable doubt. First, that the defendant caused John O'Keefe's death. Second, the defendant intended the conduct that caused John O'Keefe's death. And third, the defendant's conduct was wanton or reckless. I will now discuss each element in detail. The first element is that the defendant caused the death of John O'Keefe. Remember, Ms. Reed caused John O'Keefe's death if her actions directly and substantially set in motion the entire chain of events that produced the death. A defendant's act is the cause of death where the act in a natural and continuous sequence results in death, and without which death would not have occurred. The second element is that the defendant intended the conduct that caused the death. The Commonwealth is not required to prove that the defendant intended to cause the death. You may consider any credible evidence that the defendant was affected by her consumption of alcohol. The third element is that the defendant's conduct was wanton or reckless. Wanton or reckless conduct is conduct that creates a high degree of likelihood that substantial harm will result to another. It is conduct involving grave risk of harm to another that a person undertakes with indifference or disregard of the consequences of such conduct. Whether conduct is wanton or reckless depends either on what the defendant knew or how a reasonable person would have acted knowing what the defendant knew. If the defendant realized the grave risk created by her conduct, her subsequent act amounts to wanton or reckless conduct, whether or not a reasonable person would have realized the risk of great danger. Even if the defendant herself did not realize the grave risk of harm to another, the act would constitute wanton or reckless conduct if a reasonable person, knowing what the defendant knew, would have realized the act posed a risk of grave danger to another. It is not enough for the Commonwealth to prove the defendant acted negligently, that is, in a manner that a reasonably careful person would not have acted. The Commonwealth must prove that the defendant's actions went beyond negligence and amounted to wanton or reckless conduct, as I have defined that term. In deciding whether the defendant knew or should have known her conduct created a high degree of likelihood that substantial harm would result to another, you may consider any credible evidence that the defendant was affected by her consumption of alcohol. A defendant may have the requisite knowledge even if she consumed alcohol, but you may consider such evidence in determining whether the Commonwealth has proved this element. Now, the offense of manslaughter while operating a motor vehicle under the influence of liquor also includes the lesser offense of motor vehicle homicide, felony OUI, and negligence. As a matter of law, the indictment that is before you that charges the defendant with manslaughter while operating a motor vehicle under the influence of liquor also charges her with the lesser included offense. The Commonwealth may prove the lesser included charge of motor vehicle homicide, even if it fails to prove the greater charge of manslaughter while operating a motor vehicle under the influence of liquor. You may find the defendant guilty of motor vehicle homicide only if you are not convinced beyond a reasonable doubt that the defendant is guilty of manslaughter, and you are convinced beyond a reasonable doubt that the defendant is guilty of motor vehicle homicide. On the verdict slip, that just means you start from the top and you work your way down. In order to prove the defendant guilty of motor vehicle homicide, the Commonwealth must prove the following 5 elements beyond a reasonable doubt. First, that the defendant operated a motor vehicle. Second, that she operated the motor vehicle upon a public way or in a place in which the public has the right of access. Third, that while the defendant was operating the motor vehicle, she was under the influence of intoxicating liquor and or the percent of alcohol in the defendant's blood was 0.08 or greater. Fourth, that while operating a motor vehicle, the defendant did so in a negligent manner so that the lives or safety of the public might be endangered. Fifth, that by such operation of the motor vehicle, the defendant caused the death of John O'Keefe. Elements 1, 2, 3, and 5 are the same as manslaughter while under the influence of alcohol, as previously instructed a few moments ago. The difference between manslaughter while operating under the influence and motor vehicle homicide is the 4th element, so I'll focus on that. To prove the 4th element of motor vehicle homicide, the Commonwealth must prove beyond a reasonable doubt that the defendant drove negligently in a manner that might have endangered the lives or safety of other people. A person acts negligently when she fails to use due care. That is, when they act in a way that a reasonable person would not act. This can happen either by doing something that a reasonable person would not do under the circumstances, or by not doing something that a reasonable person would do. The defendant acted negligently if she drove in a way that a reasonable person would not have, and by doing so created an unnecessary danger to other people, a danger that she could have avoided by driving more carefully. The defendant's intent does not matter, so do not consider it in determining whether or not the defendant was negligent. There is no requirement that the Commonwealth show that the defendant intended to act negligently or unlawfully. Under our laws, public safety requires each driver to determine and to adhere to an objective standard of reasonable behavior. Therefore, what the defendant may or not have intended to result from her actions is irrelevant. The issue is whether or not she drove as a reasonable person would have under the circumstances. In determining whether the defendant drove negligently in a manner that might have endangered the lives or safety of other people, you should take into account evidence, if any, about the defendant's rate of speed and manner of operation, the defendant's physical condition, and how well she could see and control her vehicle, the condition of the defendant's vehicle, the kind of a road it was and who else was on the road, the time of day, the weather, and the road conditions, what any other vehicles or pedestrians were doing, and any other factors, including the defendant's consumption of alcohol, that you think are relevant. The offense of manslaughter while operating under a motor vehicle under the influence of liquor also includes the lesser offense of motor vehicle homicide, felony OUI liquor, and the lesser offense, and the lesser included offense of operating under the influence. As a matter of law, the indictment that is before you, which charges the defendant with manslaughter while operating a motor vehicle under the influence of liquor, also charges her with these lesser included offenses. So the Commonwealth may prove the lesser included charge of operating under the influence, even if it fails to prove the greater charges of manslaughter while operating a motor vehicle under the influence of liquor and motor vehicle homicide. You may find the defendant guilty of operating under the influence only if you are not convinced beyond a reasonable doubt that the defendant is guilty of manslaughter, and you are not convinced beyond a reasonable doubt that the defendant is guilty of motor vehicle homicide, but are convinced that the defendant is guilty beyond a reasonable doubt of operating under the influence. To prove the defendant guilty of operating under the influence, the Commonwealth must prove elements 1, 2, and 3 that I instructed you on motor vehicle homicide while OUI. So the third indictment is leaving the scene of an accident resulting in death. In order to prove the defendant guilty of leaving the scene of an accident resulting in death, the Commonwealth must prove 6 things beyond a reasonable doubt. First, that the defendant operated a motor vehicle. Second, that she operated a motor vehicle on a public way or in a place which the public has a right of access. Third, that the defendant knowingly collided with John O'Keefe. Fourth, that the collision caused injury to John O'Keefe, resulting in his death. Fifth, that after causing such injury, the defendant failed to stop and provide name, home address, and registration number of the motor vehicle. And sixth, that the defendant failed to do so for the purpose of avoiding prosecution or apprehension. Jurors, I've already instructed on the first and second elements. The other 4 elements should be given their plain meaning, and the parties agree that I do not need to define these any further, correct? Okay. Thank you. All right. As a general rule, you're permitted but not required to infer that a person who intentionally uses a dangerous weapon on another person intends to kill that person or cause him grievous bodily harm, or intends to do an act which, in the circumstances known to him or her, a reasonable person would know creates a plain and strong likelihood that death would result. An item that is normally used for innocent purposes can become a dangerous weapon if it is used in a dangerous or potentially dangerous fashion. The law considers an item, in this case a motor vehicle, to be used in a dangerous fashion if it is used in a way that it reasonably appears to be capable of causing serious injury or death to another person. In deciding whether an item was used as a dangerous weapon, you may consider the circumstances surrounding the alleged crime, the nature, size, and shape of the item, and the manner in which it was handled or controlled. That completes my second part of the instructions. I'm now going to turn to the third and final part, which is shorter. In order for a jury to return a verdict, that is, to reach a decision in a criminal case, the law provides that there may only be 12 persons on the deliberating jury, and you will note that there are 18 of you. To avoid the need for a new trial if one or more jurors becomes ill or is to be excused for some good reason, we customarily impanel extra jurors at the beginning of a trial, as we did in this case. Because of the anticipated and now actual length of this trial, we impaneled more jurors than are commonly impaneled. However, when you begin your deliberations, the law in Massachusetts is that only 12 jurors can deliberate. Therefore, at the conclusion of my instructions, Mr. McDermott will reduce your number to 12 on a random basis. The jurors not selected to serve in the jury will become the alternate jurors. If you are selected as an alternate juror, please do not feel that your efforts in this case have been wasted, because as I've indicated, it's important that we have extra jurors in case of an emergency. If we did not impanel extra jurors and a juror became ill, or for some other reason had to be excused, we would have to try the whole case all over again with a new jury. In the event that a juror has to be excused once the jury starts deliberating, then an alternate juror will be chosen to take that juror's position, and the jury will be required to start deliberations from the beginning. Therefore, it's important that the alternates not discuss the case with anyone else, including each other. For if an alternate becomes a member of the jury for deliberations, the alternate's views should be his or her own and not be influenced by anyone else. Different states and jurisdictions use different means to select a foreperson of the jury. In some jurisdictions, the jurors select their own person. In Massachusetts, the judge is responsible for selecting the foreperson. A foreperson of a jury has been described as the first among equals. He or she is responsible for organizing the deliberations, communicating with the court if necessary during deliberations, and presenting the verdict following your deliberations. The foreperson has no greater say or vote in the jury's deliberations. However, and in that sense, the juror is equal with all other jurors. I am going to ask the juror seated in seat number 1, your juror number 5, sir, would you agree to be foreperson in this case? I'm going to ask you if you would be foreperson in this case. Thank you. I always appreciate it when people say yes before I tell you what's involved, but thank you very much. All right. So the foreperson will be given the verdict slip setting forth the charges against the defendant. 12 jurors must agree. So, all right, so I skipped the line. When you return to the jury room to deliberate, the court officers will deliver to you all the exhibits in this case, as well as the verdict slips that you'll be using in returning your verdict. So the foreperson will be given the verdict slip setting forth the charges against the defendant. 12 jurors must agree before you have a decision to any specific charge. That means that to find the defendant guilty, all 12 must agree. To find the defendant not guilty, all 12 must agree. You should consider each indictment individually and continue deliberating until you've reached a final verdict. You should not begin deliberating until all 12 jurors are together in the jury room, and should cease deliberating if any one juror is not present in the jury room. It is important that you not communicate with anyone outside the jury room about the deliberations or about anything concerning this case. Further, I remind you that no juror is better qualified to determine the truth of the facts in this case, to dispute or to deliberate on a verdict solely because of education, background, or experience. The parties and I have chosen each of you as fair and impartial jurors, and your voices have equal weight. To reach a unanimous verdict, each juror must agree. Jurors have a duty to consult with one another and to deliberate with a view to reaching an agreement, if it can be done without violence to individual judgment. At the same time, each juror must decide the case for himself or herself but only after impartially considering the evidence with his or her fellow jurors. Don't hesitate to re-examine your views and change your opinion if convinced it is wrong. But no juror should surrender an honest conviction to the opinion of fellow jurors simply for the purpose of reaching a verdict. Although how you conduct your deliberations is up to you, I urge you not to begin by conducting an immediate straw vote. Rather, I encourage you not to take any votes before you've had completed a careful and thorough collective view of all the evidence. At this point, I want to remind you of an important issue that I raised with you at the beginning of this trial. I told you that our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. I also pointed out that we all have our own built-in expectations and assumptions, even if we are not conscientiously aware of them. And I talked about some of the ways we can try to deal with them. First, slow down. Do not rush to a decision. Hasty decisions are the most likely to reflect stereotypes or hidden biases. Take time to consider all the evidence. Second, as you start to draw conclusions, consider what evidence, if any, supports the conclusions you are drawing and whether any evidence casts doubt on those conclusions. Double check whether you are actually using unsupported assumptions instead of the evidence. Third, as you think about the people involved in this case, consider them as individuals rather than as members of a particular group. Fourth, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? Fifth, listen to your fellow jurors. They may have different points of view. If so, they may help you determine whether you are focusing on the facts or making assumptions, perhaps based on stereotypes. Of course, your fellow jurors could be influenced by their own unstated assumptions, so don't be shy or hesitant to speak up. You should participate actively, particularly if you think the other jurors are overlooking or undervaluing evidence you find important. In fact, when you explain your thoughts out loud to other jurors, you are also helping yourself to focus on the evidence instead of assumptions. If you use these strategies, then you will do your part to reach a decision that is as fair as humanly possible, and that is your responsibility as jurors. Now, during the course of your deliberations, you might have a question concerning the law in this case. Perhaps I said something you did not understand. If you have any questions, please feel free to bring them to my attention by writing a note dated and signed by the foreperson and sending it to me by way of the court officers. I'm not suggesting for a minute that you have to have questions, but if you do, that's the process. Because your role as the jury is to determine the facts in this case, I cannot answer any questions you have concerning the facts of the case. I have no role in this case when it comes to deciding what the facts are. Neither is it possible for me to provide you with a transcript of the testimony. If you send a question to me, I'll respond after consulting with the lawyers. Please do not ask a court officer or anyone else to answer any questions concerning anything material to the case. Generally, we will not answer a question or take a verdict from 1 o'clock till 2 o'clock, but I think you've all waited so long to get this case, I think we can change that. But the court staff needs a luncheon break. You'll have lunch brought into you, and you can decide whether or not you want to stop your deliberations during lunch or continue and deliberate. At the end of the day, if you're still deliberating, I'll send in a note asking if you want to continue deliberating or break for the day and return the next morning. Don't tell anyone, including me, how the jury stands numerically or otherwise on the questions before you until such time as you've reached a unanimous verdict. You are going to notice shortly that the court officers are going to take an oath, and you will hear from that they too, as well as all other persons, are forbidden to communicate in any way or manner with any member of this jury on any subject touching on the merits of this case. Remember that the decision of the jury must be unanimous, and the foreperson should be certain that each member of the jury is in complete agreement with the verdict on each indictment. After the final vote of the jury, the foreperson should check the appropriate boxes as to each charge, then sign and date the verdict forms and notify the court officer when you've reached a unanimous verdict. You will then be brought back into the courtroom where the foreperson will deliver the verdicts. This will be the last time I'm going to see counsel at sidebar, but I'm required to see counsel at sidebar.
So do you think if the jury gets the case, they'll come back today? There's so many holes in it. They're gonna come back not guilty in like 10 minutes. What do you guys think? How long will the jury deliberate? Do you think they'll get the case today? Let me know in the comments, please. I bet the jury's just like, let's do this, get this done before the weekend. Boom. Let's get out of here, right? Long sidebars.
May I?
Yes.
Could the juror sitting in seat number 13 step down and take your place as an alternate? Could the juror sitting in seat number 7 step down and take your place as an alternate? Juror 6, could you step down and take your place as an alternate? Juror 17, could you step down and take your place? Juror 8, could you step down and take your place as an alternate?
All right. Yes, please do.
Could I have the court officers raise your right hands? Do you swear that you will keep this jury in alternates and some separate but convene and place them to the degree that you not suffer any person to speak to them, nor speak to them yourselves, nor ask them if they agree, nor suffer them to disperse until they have discharged their verdict, except by further order of the court, so help you God. Thank you.
All right, so members of the jury, I need not remind you that you have an important responsibility, but I believe that you will bring to bear all the wisdom and the judgment and conscience that you possess in reaching your verdict in this case. All that we can expect from you is that you decide the case with integrity and with principle. We all expect you to reach an impartial verdict dictated by your logic, without bias, without prejudice or sympathy, and not prompted by any facts except those that you've heard here in court during the trial. We are looking for impartial judgment dictated by your reasoning and the fullest discharge of your oaths as jurors. You may retire and deliberate your verdict.
Jerry, make sure you take your oath with you, please.
I'm going to see counsel one more time.
Judge, the first thing is, council this morning and yesterday looked at exhibits, and I believe that we were pretty close. We had one exhibit that needed to be dealt with. Ms. Little, what number is that one again? 150?
Yes, this is exhibit 155.
155, and I'll let Ms. Little take it from there.
Yes, there's just one page, Your Honor. I believe, and my memory's not perfect, but I believe that we were gonna have this redacted, subject to the same redactions from last trial. I think there's just one line here that needs to be redacted.
Okay, is the Commonwealth in agreement with that one line?
No objection, I believe it was redacted last time, so if defense
Okay.
wants to make that redaction, you can go into evidence.
Great.
See that Sharpie and maybe I can see here.
I think we probably have one here you
I
can
have
have.
one. I definitely have one somewhere.
All right.
That's number one. And number two is, can council look at the verdicts and just tell me, if verdict slips, and just tell me if they're okay with it? Okay.
You'll see that it's not what you provided me yesterday, Mr. Kennedy.
anticipated that.
Getting their last minute huddle on. Get them their last minute. We can do this. Don't be jail system. But again, out of all this, I hope she learns to quit drinking and driving. She may not be so lucky next time. He's a bitch.
Just waiting first.
On chicks, Dave. We'll bring her.
Council, you can keep doing that. Mr. Rose,
That'd be cool.
can you raise your right hand? Do you solemnly swear that you will keep that jury in some separate but convenient place until they agree that you not suffer any person to speak to them, to speak to them yourselves, nor ask them if they agree, nor suffer them to disperse them, to charge they burn, except by further word of the court, so help you God? Simply because you were in the room. Thank you. Is the Commonwealth content with the verdict slip?
Almost content. So, Your Honor, I understand that you projected our proposed verdict slip.
So everybody else can sit down. Mr. Yannetti can stand.
Thank you. I understand that you projected our proposed verdict slip. Our concern with this verdict slip is that there are 4 options for, actually more than that, 7 options for guilty verdicts, 1 option for not guilty. And we're concerned that this is too confusing for the jury. So we are asking that there be not guilty options for each of the charges, including the offense charged and each one of the lesser included offenses. We really ran into the same issue last time. I think what complicates it is fact that there are two theories for two of the lesser included.
Do you suggest that doesn't accurately reflect the law?
It does reflect the law. I'm not saying that. I'm saying that it makes things very confusing, and that's why we believe that it cries out for some not guilty option, given the amount of options for convictions on this verdict slip. So
Okay.
we would again ask the court to adopt our proposed verdict slip.
So your proposed verdict slip did not cite any case law. Do you have any case law that supports that proposition, Ms. Giannetti? I have not found any. I've looked.
There's not a lot of case law out there even to support this verdict slip either.
Other than that has never been proven, has never been found to be inaccurate.
Not yet.
Okay.
And I mean that
So
with all respect.
that's fine. So your rights are reserved. Does that help you?
Right, well, all we can do is object to it, and you make
Okay.
the decision.
Okay.
Judge, the last couple.
If you find authority for that, let me know.
With a clean laptop, defense counsel had a chance to, or at least defense had a chance to look at it, and I think it's fine.
All right, so we'll send that in with the exhibits. I need to go edit my charge to fix all the typos.
And then the final thing is I provided counsel with the exhibit list that we had, and it was satisfactory for both sides.
Great.
Thank
All
you.
right, thank you.
All rise for the court, please.
Totally missed that. Did they take a break? Tiny fishnet stockings. I'd like to wish a happy anniversary to Jennifer in the Facebook family chat. Hope you have a great weekend. And we're having a break, so I'm gonna take a quick break. I'll be right back. Oh, verdict watch. I apologize. See, such a blondie, but it's Friday and it's been such a long week. Jury watch.
There's no way that that happened, but their ending was good. Recall, they being the prosecution, recalled to some of the things that the defense did. The most ridiculous thing I think they did was presented this whole thing about the possible dog bite. And they were able to kind of take that and say, there's no scientific way. This person that they got to testify about the dog bite never has. They don't know anything about dog bites. They don't know what they look like, what they smell like, etc. So that's a good last thought to say, hey, go back to your common sense. Go back to the evidence that we have. And here it is saying that she's guilty beyond a reasonable doubt.
But Joe, the fact that you were able to just articulate so well either side, isn't that reasonable doubt? Isn't the fact that we really don't know what happened and you could argue either one, isn't that enough theoretically to be reasonable doubt?
There's no doubt about it. And to be honest with you, if I had to pick a pony, I would say the defense is in pretty good shape here because it's just not as clear as it needs to. Sure, the prosecution had some things to say, but the defense, the idea that the chief investigator was not testifying at all this time means you make the whole case about him. That's what the defense was going to do. The prosecution tried to sideswipe it a little bit, and they did the best job that they could, but it's truly taking the lemon and making lemonade, because if you were so sure Proctor would be a central witness, not just somebody that's talked about centrally, but the jury doesn't get to hear from.
Yeah, it doesn't get to hear from. Huge in this case, in my opinion. All right, just in the last few seconds, does it make a difference to, darn it, I lost my train of thought. I had such a good question I had to ask you to, is a hung jury a win for the defense? If there's another hung jury, do you count that as a win?
Absolutely, because they're over 2. But what they really want is they want an absolute acquittal, and I think that it could happen. And I don't know if they're going to prosecute her a 3rd time.
Wow, it might happen. All right, we don't know what's going to happen. We're going to keep an eye on the verdict clock. It's 11 minutes, 25 seconds. Again, the jury is deliberating in the Karen Reed case. And you don't want to miss this, Matt Johnson is joining us live next. He is there outside that courthouse. Look at the people gathered. We'll bring you that up next here on Court TV. Welcome back to Court TV Live. I'm Judge Ashley Wilcott. Of course, honored to be with you today. Court TV is in Dedham, Massachusetts, where the fate of Karen Read is now in the hands of the jury. You can see the clock is up. 16 minutes is how long this jury has been out deliberating. Read's first trial, of course, ended in a mistrial last year after the jury could not come to a unanimous decision about whether or not Read intentionally struck her boyfriend, Boston police officer John O'Keefe, with her Lexus SUV. Prosecutors point to fragments of Read's taillight at the crime scene as evidence of a collision, but the defense believes that Read is the victim of a wide-ranging cover-up by O'Keefe's friends and local law enforcement. Right now, let's bring in Court TV crime and justice correspondent Matt Johnson, who is live outside of the courthouse. I say this every time to remind everyone, Matt, that you were there the entire first trial. You've been there the entire second trial. So tell us, if you would, please, first, the mood at the courthouse right now.
Yeah, it's a bit of deja vu, Judge Ashley. We are standing outside the courthouse here in Dedham, Massachusetts. This jury, the deliberating jurors, are now in that jury room, and we are officially in a verdict watch. Just a few minutes ago, this defendant, Karen Read, along with her attorneys, were walking down the courthouse steps, making their way through the crowd of supporters, hundreds of people that are here at this courthouse in Dedham Square, along with media from all across the country. They are all also in silence as they stand behind this defendant. Let's listen to Alan Jackson from earlier today. Take a listen.
This means more to us than you can imagine. If the volume comes up even a little bit, we're gonna be ordered to stay in the building, and y'all are gonna be ordered off the lawn. So just please do us that favor. This means as much as you yelling out. Bless your heart.
Thank you, Jackson.
All right, and again, just moments ago, as I mentioned, they just left the courthouse here as we're in verdict watch. Let's listen together.
Guys, we're not going to make any comments right now. We will see you in a couple of minutes, though.
David, how will you spend the time waiting?
David, were you in there this morning?
You'll eat something?
Wait, I get a no comment from David after all this time?
I was in the courtroom. I was not in the, I was in the courthouse, not in the courtroom.
Yeah,
All coming up, guys. All coming up. Here, left. Sorry.
Random nature.
Yeah.
Mr. Ninetti, were you surprised we didn't have the correct script at a time?
You okay? Right here, basically. There's no bag? Wait a minute. Sorry, guys. Oh, is this me, John? I'm sorry. Right around the other side. I'm next. All the lawyers are next. Awesome. Thank you.
Very much resembling what we saw this time last year, the number of supporters for this defendant growing in numbers, many of them wearing pink, but they are being silent this year because they are within the buffer zone and they are told not to hold any signs or to make any noise, shouting or cheering. So we haven't heard that much. But last year, if we are going to compare again, the deliberations ran approximately roughly 3 to 4 days over a span, and of course that ended in mistrial. Today, we're learning that they are allowed to deliberate, this second jury, until 5, maybe 5:30 today.
All right, Matt, now tell us what specifically do we know about this jury?
Right, so 11 weeks ago, jury selection began here at the courthouse behind me. So what was impaneled was a panel of 18 jurors that heard the case all the way through. We did not lose a single juror throughout the process. We had 9 men and 9 women. It was a complete split, and they heard testimony from 49 witnesses over 8 weeks of trial. The deliberating jury, we just learned just moments ago, that is comprised of 5 men and 7 women. The jury foreperson chosen by the court, that person is seated in the first seat of the jury box. That was the case last year as well, and as I mentioned, that's a man.
All right, now talk about these closing arguments. I'll tell you what, they both came prepared. No surprise, you've got very good, zealous, great attorneys on both sides. What stood out to you about these closing arguments, Matt?
That's a good way to put it. Very zealous, very energized, and completely silent courtroom. And keep in mind, it's a very tiny room. We had Alan Jackson and Hank Brennan, the special prosecutor, squaring off for the closing remarks. The defense goes first in the Commonwealth of Massachusetts, doubling down on reasonable doubt and a faulty police investigation, as they put it. And the prosecution, the Commonwealth, doubling down on her own admissions, playing clips of TV interviews, but also each was referencing their experts, especially their crash reconstructionists. Let's listen.
There was no collision. There was no collision. There was no collision. You folks are the last line of defense. The last line of defense between an innocent woman and a system that has tried to break her.
She made a decision about herself. In her Lexus, she drove away. She was drunk, she hit him, and she left him to die.
The day started with the judge, Beverly Cannoni, who presided over the first trial, saying, jury members, you take copious notes, but you have to put those notebooks underneath your seat. Some jury members take so many notes, they have a stack of notebooks from this 8-week process. Today, they were fixated on these attorneys that were delivering those powerful closings. Judge Ashley?
Thank you, Matt. Very powerful closings, and they have a lot to talk about back in the deliberation room. Thank you to Matt Johnson, as always. I'd like to welcome our guests for this hour. Joining me in the studio, we have trial attorney Miguel Custodio, and also joining us, trial attorney Jean Rossi. Thank you, Miguel, for being here in person with me. Always appreciate you. Let me start with you, please. Tell me your thoughts, as this jury has now been out for 23 minutes, and what you think it might be like or where this might go.
I think, first off, hats off to the closing arguments by both sides. They were masterful arguments. I thought Jackson really played into the passion and the corruption theme, whereas Brennan was just about data and just facts. He was very methodical, and I thought that was great. I personally think that the jury here is going to be very, very confused about where to go. I really think that there's a lot of doubts that have come up here as to the investigation of the police, and I think that really just doesn't sit well with jurors.
Yeah, I agree with you. This jury has so much on their plate. Jean Rossi, of course, great to have you. But Jean, tell me, what do you think about where this jury might be, and how do you think it all shook out with each side, really excellent attorneys on both sides?
My view is this, based on winning some and losing some. When you have two powerful closing arguments in a case that focuses on data, and there's no eyewitnesses, and there's a lot of conflicting testimony, I think that inures to the defendant's benefit. That's point one. Number two, if we get a verdict today, it's going to be not guilty. But we're not going to get a verdict today. The jury is exhausted. They want to go home. There was a mention of the stacks of notes. They're going to deliberate probably till 5 p.m. today and come back Monday. I predict a verdict by late Tuesday or Wednesday. And if I had to bet money, if I was in Vegas, I think the odds are in favor of her getting, at best, an acquittal, and at worst, a hung jury. And here's why. It goes back to what I said a couple days ago, Judge Ashley. When you have a battle of experts, and you know, the prosecutor kind of led with his chin in the sense this is about data. Well, if you have a battle of experts and one side says, oh, there was this hit and then the car was moving this way and that way at the right time, and then you have another couple of experts that said, no, this didn't happen, a jury is going to be torn with that. And I think that the defense looked at the first trial and pruned their case in a brilliant way. And we talked about this a couple of days ago, where they got rid of some witnesses in the house, so they got rid of all that stuff, and now they're just focusing on data. So when the prosecutor said this is a case about data, it could easily be said that defense is about data. So that's why I think it's leaning in my gut, my Malcolm Gladwell gut, is that she has either a hung jury or an acquittal.
Wow. All right. So, Miguel, weigh in on that. And I have to say this, as Matt said, 3 to 4 days last time when there was a hung jury, Gene. And what must it be like? 2 questions for you. First of all, where do you think they might land? But second of all, what must it be like for any defendant, much less a Karen Read, that the entire nation, likely world, is following, watching, and either supporting or not, to have to wait while this jury deliberates?
I think there's going to be a hung jury again, and I just don't know if the prosecution really convinced the jury here in this case. I mean, there's just too many little holes here that I think creates a reasonable doubt. Karen Read right now is probably very confident. I think she's very confident in what's going on. Obviously, she's nervous. She's very, scared of what's going on, right? Because there's always a consequence that she can go to prison. But I really think that she's in a really good position right now.
And I'll tell you, watching her today, no comment when they left the courthouse, when the jury began deliberating. That's unusual. She's been saying things. She seems very hopeful. This time, she didn't have anything to say. I want to listen together, gentlemen, and then circle back to Eugene, what the judge had to say about the jury instructions, because we know the defense was concerned about them, argued for some changes because they wanted to be clear what was in those. Let's listen to that together, please.
And I will give some version. I know that there was a lot of attention paid and some appellate decisions on the each individual indictment. I'll give some further language on that. You've got an instruction and proposed on page 4, reaching a verdict. I will make it crystal clear, though. I think it was, and I was upheld on it, so I will make it crystal clear.
All right, let me ask you, Gene, because I believe that you may know this judge, and I think to me what it meant was, listen, it was clear before, but I'll look at it again because we want to make sure the jury knows exactly what the law provides for that they have to follow.
Absolutely. A full and fair disclosure. I'm a big fan of the judge. We teach at Harvard trial advocacy law. And I was the courtroom deputy in the mock trial. So I was the one standing in front of her, sitting in front of her, swearing in the witnesses at the mock trial. So I like her a lot. But this is the nerd in me. I love jury conferences. I can't tell you how many trials I've had where I've gained a little advantage or lost an advantage of significance during the discussion about what you're going to read to the jury. And I can't tell you how important jury instructions are, because whether you're defense attorney or the prosecutor, you're going to hold them up or refer to them, and they could help decide your case and create either a guilty, hung jury, or an acquittal.
I absolutely agree with you because, Miguel, the jury instructions, I mean, that's where the rubber meets the road. They go back there, they decide which facts they agree on or don't agree on, and then they have to look at those to say, and this is the law we have to apply. If there's any bad wording, wrong wording, confusing wording, it can throw a jury completely.
Absolutely, because we got to remember, jurors are lay people, right? So they are not exposed to this type of language on a regular basis. And so every single word matters that they're reading in terms of the jury instructions. So it's very important that it's clear, crystal clear.
Yeah, you're right. That's a great point. It's lay people that are having to make this decision and follow those instructions. Well, good news. We get to listen to those jury instructions of the closing arguments, which is why we're just now getting to the jury instructions, and those are up next. Stay tuned.
The WNBA is on iron. The Sky take on the Dream in the air. She started to cook. The Wings fly out west to battle the Aces. Vintage Chelsea Gray. Coverage begins tonight at 7. Find Ion wherever you watch. Ion, it's on.
Tonight on Closing Arguments, it's been the murder retrial of the century. We break down today's closing arguments as a jury will soon decide Karen Reed's fate.
Closing Arguments, tonight at 8, 7 Central, only on Court TV.
So I hope it's all right if I just leave this on. I don't see the point in switching or listening to some elevator music, but if you have something else you want me to switch to for Verdict Watch, just put it in the comments. Lori Daybell is over, so no sense in starting a new trial on a Friday. I figure we just watch this and see where it goes. Let me know if you want me to change it. I'll make a sandwich. I'm starving. Be back.
Sure.
We will get back to the Karen Reed murder retrial in just a moment, but first, here's a quick look at some of the other cases that we are tracking here at Court TV. In New York, rapper known as Kanye West showed up to federal court in support of Sean Diddy Combs at his ongoing criminal sex trafficking trial. And in South Carolina, the prosecution is expected to rest its case in chief today in the Coroner Affair murder trial for Megan Jackson. You can stream her trial live on CourtTV.com. Of course, we will continue to keep you updated on both of these trials throughout the day. Now, though, let's go back to Massachusetts, where almost exactly a year ago today, we were listening to the closing arguments in Karen Reed's first trial. Of course, that trial ended in a mistrial after the jury was unable to reach a unanimous decision about whether or not Reed fatally struck her boyfriend with her car and then left him to die in the snow. John O'Keefe was found dead outside the home of fellow officer Brian Albert's house, who was noticeably absent from Reed's trial this time around. Right now, this second jury is out deliberating. So in the meantime, we're going to go back to court. We want to hear the jury instructions read by Judge Canoni to the jury.
All right, jurors. Going to give you the instructions now in the law. But first, I want to thank you for serving on this jury and for being so attentive. You'll soon deliberate for the purpose of reaching a verdict, but before you do that, it's my responsibility to give you the instructions concerning the law. These instructions are divided into 3 parts. The first part, general instructions that are provided in every criminal case. The second part, specific instructions concerning the crimes alleged in this case. And third, guidelines for your deliberations. Please listen carefully to all of the instructions. Do not ignore any instruction or give any special attention to any other instruction. To make sure that I give you the instructions accurately, I will read them to you. You'll also get a written copy so that you may refer to it in the jury room during deliberations. I will try to make sure that my oral instructions match the written instructions. If there is any difference between what I say aloud and what the written instructions say, please follow what I say aloud. You must take the law as I give it to you. You may not quarrel with it. You can't do that regardless of any opinion you may have as to what you think the law ought to be. Lawyers or witnesses may suggest something about the law. That's not necessarily the law. That's because it's my responsibility as the judge and mine alone to instruct you what the law is. I'll now turn to part 1 of these instructions, which are general instructions that apply to all criminal cases. As I've explained to you at the beginning of the trial, there is a fundamental rule that applies to all criminal cases, including this case. Every person who is accused of a crime is presumed to be innocent of that crime. Ms. Reed is presumed innocent of the charges in this case. That means you must consider Ms. Reed to be innocent unless the prosecution has proved beyond a reasonable doubt through evidence presented at this trial that Ms. Reed committed the crimes charged. I'll explain what I mean by reasonable doubt in a moment. Ms. Reed does not have to do anything to convince you that she is innocent. She does not have to explain anything. She does not have to testify, call, or question witnesses, or provide any evidence at all, because you must presume she is innocent. Instead, it is up to the Commonwealth to prove the charges against Ms. Reed beyond a reasonable doubt. This burden of proof never shifts to the defendant. After you have considered all the evidence carefully and fairly, if you have a reasonable doubt about Ms. Reed's guilt in a particular charge, then your verdict must be not guilty on that charge. You may find Ms. Reed guilty of a charge only if all 12 deliberating jurors agree that the Commonwealth has proved the charge beyond a reasonable doubt. Now, what is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I have told you that every person is presumed to be innocent unless and until he or she is proved guilty, and that the burden of proof is on the Commonwealth. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. How do you decide whether the Commonwealth has proven that each element of an indictment is true beyond a reasonable doubt? Let's talk about the roles we all have. First, the function of the jury. You are the most important people in this room. It all begins and ends with your function. You will determine the facts in this case, and that is your job and yours alone. You are the sole and exclusive judges of the facts. If there are any conflicts in the testimony, it is your job to resolve those conflicts if you can do so. Once you determine the facts, it is your duty to apply those facts to the law as I explain it to you, and to determine whether the Commonwealth has proven its case beyond a reasonable doubt. You must decide the facts solely and entirely on the evidence as you have seen. No fear, no favor. You must not be swayed by personal likes or dislikes. Your deliberations are no place for emotion, sympathy, passion, or prejudice. The Commonwealth and Karen Reed have a right to have the case judged by fair and impartial jurors. All parties who come before the court stand as equals before you. Therefore, your verdicts must be based on the law as I'm giving it to you, and on the evidence and the facts that you find, and nothing else. You cannot allow yourselves to be influenced by any personal feelings you may have about the nature of the crimes with which Ms. Reed has been charged or the consequences of your verdict. Just the cool, reflective, and impartial sifting of the evidence so that here in this courtroom, justice may be done. Your focus is on the evidence. I am the judge of the law. My job is to teach you the law that you must follow in the case. However, I have no opinion about how you should decide this case. You should not consider anything I have said or done during this trial as reflecting any opinion by me about how you should decide this case. If you believe I have an opinion about the facts of this case, you must disregard it. You must decide this case based solely on your evaluation of the evidence. The arguments of the lawyers are not evidence, they are not witnesses. If a lawyer during argument made a mistake in summarizing the evidence or argued something not supported by the evidence, you must disregard it. It is the...
All right, so these are standard things that you're going to hear in jury instructions. Follow the law, the presumption of innocence. If you think I, the judge, have an opinion, disregard it, because that's not what you're to consider. We're going to take a break here. When we come back, of course, we'll get you back in for more of the jury instructions.
Did you see all of those people outside? A lot of people wondering what's going to happen with this case. A ton of people out there. It's nuts. They don't got JOBs. Maybe they took their perfect, last trial, everybody was for free Karen Reed, and I think there's some people out there that are seeing it a different way. We'll see. I think the jury will be back today, so I'm going to go ahead and wait and stick it out. I hope you guys do too.
Welcome back to Court TV Live. I'm Ashley Wilcott. Thanks so much for being with us. Let's turn now back to Dedham, Massachusetts, where we are on verdict watch this afternoon in the Karen Reed murder retrial. You can see the clock is on your screen. The jury's been deliberating for about 50 minutes. They're to decide if Reed is guilty or not guilty in the death of her boyfriend, Boston Police Officer John O'Keefe. Right now, we are listening to Judge Beverly Cannoni instruct the jury. Very important, the jury instructions, that's the law. They have to apply to the facts as they find them. Let's go back into court.
Lawyers' objections are a proper part of the court procedure and are not part of the evidence. So don't hold it against the lawyers or their client if they made objections, motions, or other requests. They're simply doing their job during the trial. There was testimony at trial that the lawyers interviewed witnesses when preparing for the trial. You may not draw any unfavorable inferences solely from that fact. There is nothing improper about conducting such interviews. On the contrary, the lawyers are obliged to prepare their case as thoroughly as possible and may interview witnesses. The verdict must be based only on the evidence and the jury's collective reasoning applied to the evidence in a fair and impartial manner. The extent to which you believe or disbelieve a witness or what an exhibit purports to show, and the importance to give any testimony or other evidence is entirely up to your own good judgment. The evidence consists of the testimony of the witnesses and the exhibits that were introduced in this trial. You will have those exhibits with you in the deliberation room. In addition, as you heard during the trial, the prosecution and defendant agreed that certain things are true. Therefore, you must accept those things as true. There are some things you have heard about that have not been introduced into evidence, such as previous testimony of witnesses, police reports, autopsy and accident reconstruction reports, and perhaps other reports. You may naturally wonder why neither side has introduced any of them into evidence. The answer is that under our rules of evidence, such reports usually may not be admitted, although the parties may refer to them for certain limited purposes while questioning witnesses. So you should not hold it against any party that you do not have them, and neither should you speculate on what they may or may not contain. Similarly, as you review the exhibits, you may find that some information has been removed because it is not relevant. Please ignore that and don't try to guess what may have been removed from there. Any information that you may have read, heard, or seen about the case outside of the courtroom is not evidence. My instructions to you and any other comments I made, the lawyer's opening and closing statements and any comments they made are not evidence. If the lawyers or I made any comments during the trial, those comments are not evidence and you must base your verdict only upon the evidence. In an interaction between a lawyer and a witness, you may consider only the witness's testimony as evidence. Answers that I struck from the record and told you to disregard are not evidence. Only the testimony of the witness, that is, their answers to the questions and the exhibits are evidence. Finally, on this topic, if one of the lawyers or I refer to some part of the evidence and that does not coincide with your own recollection, it is your collective recollection which you are to follow in your deliberations. It is important to remind you folks that the verdict cannot be based on emotional reaction or sympathy for any person or side of this case. Certain of the testimony and exhibits may have provoked an emotional reaction in all of us. You may feel sympathy for the family of Mr. O'Keefe, and you may feel sympathy for the defendant as she sits here in the courtroom. But your job is to decide the case without bias, fear, sympathy, or favor, to view the evidence with a certain clinical detachment, and to decide the case based solely on the evidence and the application of the law. I have allowed you folks to take notes during the trial if you chose, and you may refer to those notes during your deliberations. But remember, they are not evidence or a substitute for the evidence and your recollection. They are for your personal use. Please do not share them with the other jurors. Please consider the evidence as a whole. Do not make up your mind about what the verdict should be until after you've gone to the jury room to decide the case and you and your fellow jurors have discussed the evidence. Keep an open mind until then.
Still with us, Miguel Custodio and Jean Rossi. Miguel, you and I were talking about jury instructions, including some of the normal things. One of them is jurors, use your common sense. Don't leave that at the door. And we were talking about the prosecution's evidence that that car that she was driving accelerated and then backed up 24 miles an hour. What are your thoughts?
Well, I've had cases where I'm representing a pedestrian in civil cases against a vehicle that hit them. And for a vehicle to strike, in this case, 6,000-pound car to strike him, he was stationary, strike him at 24 miles per hour, the body will leave a lot more marks than what you see that left with him. So you would see bruises, you would see a lot of bruises, a lot of purple. And all he had was a scratch on his eyelid and on his nose and some scratches on his arm that, hey, most likely can be a dog bite. So I thought it was common sense will, I think, win here, and that's why I think that the defense, will get either a hung jury or acquittal.
And that common sense piece, I have to say this though, Jean, in the first trial, the defense obviously put up a lot more evidence about that conspiracy theory and cover-up, and more people from inside the home testified for the Commonwealth, and the defense was able to use that to really say, there's something shady going on there, and it included a cover-up and hurting John O'Keefe. That wasn't present this time. So how do you think common sense might come into play?
I think common sense is going to be one of their last witnesses for the defense, that crash guy who reconstructed and said it's not consistent with somebody being hit. But I want to focus on a jury instruction that's going to decide this case, in my humble view.
What is it? Tell us.
It's the money jury instruction, and Judge Cannone, I call her Cannone because I'm from Connecticut, but Judge Cannone and I talked about this instruction when we were teaching together. You have to find by a moral certainty that she is guilty. In federal court in the Eastern District of Virginia, which is less than a half a mile from my house, that instruction would never be given. In Massachusetts, it's a beautiful instruction for the defense. A moral certainty, and it's what I said a couple of days ago. They have to go home, look at a mirror, and say, to a moral certainty, she's a murderer. I don't think you're going to get 12 jurors to say that she's a murderer to a moral certainty, based on the evidence in the last few weeks. No way. I think at worst, she's got a hung jury. At best, of course, it's an acquittal.
Jean Rossi, it's like you read my mind, because I had written down to a reasonable and moral certainty, because it stood out to me as that's not always in jury instructions. So I'm so glad you've addressed that and what you see as a win for the defense. Let's listen together, because I do want to listen to a little bit of closing argument by the Commonwealth and what they said about Reed being drunk and how that might affect it. Let's listen.
She made a decision. In her Lexus with the shattered taillight, debris field all over the front yard, and John O'Keefe lying helpless like a child on the front yard. She made a choice. She didn't call 911. She didn't run to his aid. She didn't knock on a door. She made a decision about herself. In her Lexus, she drove away. She was drunk, she hit him, and she left him to die.
What do you think, Miguel? Intent or no intent? Knowing they're saying she was drunk, well, did she really mean to do this?
If you're drunk, and we know that the stats here show that she was drunk 2 to 3 times over the legal limit, I just don't see how you get that intent. I really just don't. It seems very hard for me. I don't think that they met that burden, and it's going to be really hard.
All right, the intent. Do you think there's any opportunity for that to be a conviction, Gene?
Oh, no. I mean, I could lose my bar license betting it, but it gets to alcohol. Alcohol, if you have a specific intent crime, alcohol brings it down, it negates specific intent. That's number one. And number two, obviously there's some jurors that are familiar with intoxication, and they're going to put themselves in her shoes in that car, and if the prosecutor's theory is correct, that she backed up and ran him over, the prosecutor's kind of arguing against himself because she's drunk. Well, how can you develop this specific intent to murder him and make that choice? I'm going to leave him for dead. Those are two inconsistent positions in my view. Negligent homicide may be an argument they could make, but not the charges that they have at the top of the list.
And that's why I think there are legal analysts have said they think that the Commonwealth overcharged her because of exactly what you just described. I'm not saying they did or didn't. I'm just saying a lot of people feel that way. All right, stay tuned. We'll get you back inside the courtroom for more of the jury instructions up next.
Karen Reed is in the midst of the retrial of the century.
She is factually innocent. She's guilty.
There's something wrong in this county.
Come at me.
John O'Keefe was killed by that defendant, Karen Reed. She's the victim of a corrupted investigation that was never about the truth.
Another big day here at the Dedham courthouse.
Fight on. Nothing's breaking me, Matt.
You'll see it all unfold right here on Court TV.
The Karen Reed murder retrial. Live coverage today on Court TV.
Okay, there's a clip that I watched last night of Karen Reed after, I don't know, I just saw a ton of people on TikTok just how great Karen Reed is. So let's watch this real quick. It was pretty interesting to me. She doesn't care. She has no remorse. She does not miss John. Listen to this.
So then we take marshmallow, right? And we find stick. Maybe we can use the
See, John died 2 years, 2 months ago. And there's been, an evolution of my emotions about John that
I'm trying. Hold on, I'm sorry.
of 2 years, and now
So then we take marshmallow, right? And we find stick. Maybe we can use the
see, John died 2 years, 2 months ago, and there's been, an evolution of my emotions about John. That the funny thing is, I've now eclipsed the time I knew John. I mean, I knew him when we were younger, but the time I actually dated him more seriously the second time around was just 2 years, just shy of 2 years. And now he's been gone 24 months. I think anybody who witnessed us around Canton at kids' sporting events or out to eat or at bars would say we were always getting along.
You had occasion to meet or see Karen Reed over the course of hanging out with your brother at various occasions, correct?
Correct, yep.
What, if any, occasions, as far as their arguing or anything like that, did you observe personally yourself?
I witnessed, one intense fight
between the two of them.
And as far as the fight as you're characterizing that, was that anything physical or just verbal?
No, it was a verbal argument.
And what, if anything, was that verbal argument about?
It's hard to recall. I mean, I guess like typical couples fighting. There was alcohol that had been involved. I recall her complaining that, he wasn't nice to her, or, something to that effect. And
2 days before, I care less about fighting for John. I care less about fighting for John.
Did you hear that? Less about fighting for John.
So then we take marshmallow, right? And we find stick. Maybe we can use the
See. John died 2 years, 2 months ago. John died 2 years, 2 months ago.
And I've now eclipsed the time I knew John. I mean, I knew him when we were younger, but the time I actually dated him more seriously the second time around was just 2 years, just shy of 2 years.
And now he's been gone 24 months. I think anybody who witnessed us around Canton at kids' sporting events or out to eat or at bars would say we were always getting along.
You had occasion to meet or see Karen Reed over the course of hanging out with your brother at various occasions, correct?
Correct, yep.
What, if any, occasion?
Whether they find her guilty or not, she has zero remorse. She only cares about her next time. They've been deliberating for almost exactly 1 hour. Uh-oh. There's not a verdict already. Wonder if they have a question. Or if they want to go home. The band's spinning. Band is spinning. I'm trying to figure out why they turned everything on. If something's coming, I'll try to find out. I'm gonna try to find out. I'll be back.
cannot do that today.
All persons have any business before the Honorable Beverly Canoni, Justice of the Norfolk Superior Court, before the County of Norfolk. Draw near, give your attendance, you shall be heard. I state the Commonwealth of Massachusetts. The court is now open. You may be seated.
All right, good morning, counsel. Good morning, Ms. Reed. Good morning, jurors. I have to ask you those same 3 questions. Were you all able to follow my instructions and refrain from discussing this case with anyone since we left yesterday? Yes. Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left here yesterday?
Everyone said no or shook their heads. Thank you. We have Dr. Rentschler again, please.
I want to say that they probably didn't